Ms. Holland, good to see you.
Good to see you too, Your Honor. Good morning, Your Honors, opposing counsel, and may it please the court. My name is Josie Holland, and I represent the appellant Marcus Somerville. I'd like to reserve 4 minutes for rebuttal, please. This appeal challenges the denial of judicial diversion for Mr. Somerville, a first-time offender convicted of a Class C felony who was sentenced to incarceration. The trial court's discussion is flawed for 2 principal reasons. First, the trial court failed to conduct the individualized assessment of diversion eligibility that Tennessee law demands. Rather than weighing the Parker and electroplating factors as applied to Mr. Somerville, his unique circumstances, the court relied on its own sentencing patterns and focused on a categorical denial and speculative risk in the future. Appellant will address 3 main points. First, the trial court's failure to conduct the individualized assessment and abuse of discretion. Second, the legislature's intent and public policy underlying diversion and why Mr. Somerville's case fits squarely within those considerations. And finally, the due process deficiencies in the plea and sentencing proceedings and the appropriate remedy.
Ms. Holland, can we work backwards here and maybe start with the due process issue? Did the defendant plead guilty?
That's not entirely clear from the record, Your Honor. That is our concern.
I've been looking at this transcript and the briefing, and for the life of me, I can't see where he pled guilty or was otherwise found guilty beyond a reasonable doubt before he was sentenced to prison.
Yes, Your Honor.
Am I wrong? Am I missing something, I guess is my question.
No, Your Honor is not missing anything at all. It is a due process procedural failing. The trial court's handling of the plea and process was procedurally irregular and constitutionally deficient. The sequence and clarity of the plea proceedings were fundamentally flawed. During the...
What plea proceedings?
Well...
I didn't see plea proceedings.
I agree with Your Honor. I agree that there's a real first hurdle in this case for the state in proving that there was an affirmative clear plea as required by Boykin versus Alabama, Mackey, and several other cases from the United States and Tennessee.
Well, let me ask you, I don't think we're going to sort that out here today, but if there wasn't, the state has argued in their brief that that is not required necessarily under the diversion statute, that you could proceed to a judicial diversion hearing and make that determination prior to a guilty plea or a finding of guilt. What's the appellant's response to that?
Your Honor, I must respectfully disagree with the state's position as to that issue. If that were the case, Your Honor, someone could be denied diversion at arraignment. That's illogical and not consistent with Tennessee's sentencing statutes. If the case were that someone did not need to clearly and affirmatively plead guilty, he could simply lose his ability. The judge could decide he couldn't have diversion on the first day of the case, and sort of taking that argument to its, most absurd. But if the state's making that argument, it certainly is a concern as it relates to due process because of the requirement of clear and affirmative, intelligent, knowing, voluntary pleas. During the June 17th hearing, the parties agreed that Mr. Somerville had not entered a plea, and the record does not clearly reflect that Mr. Somerville affirmatively pleaded guilty prior to the imposition of a sentence. I believe in the last argument, someone was pointing out that a judgment must take place before sentence is granted. Mr. Somerville, this raises a serious question as to whether the trial court adequately considered the plea and whether Mr. Somerville's rights were properly protected through the process. Secondly, the advisement of rights was done in a group setting, not in a personal, individualized plea colloquy. And the record does not show that Mr. Somerville was advised of all his rights or the specific consequences of a felony conviction. And these are not mere technicalities, Your Honors. These are basic safeguards of due process required by both the United States and the Tennessee Constitution. Tennessee Supreme Court and the United States Supreme Court have long held that a guilty plea must be entered knowingly, voluntarily, and intelligently with a clear record of defendant's understanding and waiver of rights. Turning to the diversion issue, though, Your Honors, should you reach that point. The trial court failed to conduct the individualized assessment of Mr. Somerville's eligibility for diversion that Tennessee law requires. Tennessee courts have made clear, most recently in State v. King and consistently in State v. Parker, that a trial court must consider and weigh a set of factors on the record. These include the accused amenability to correction, the circumstances of the offense, criminal record, social history, physical and mental health, deterrence value, and whether diversion serves the interest of the public and the accused. The court must identify which factors are relevant and explain how they apply to this case. This is not a mere formality. This is a substantive requirement. It's a substantive requirement to ensure individualized justice and meaningful appellate review. Here, the record shows that the trial court did not engage in the required analysis. Instead, the court focused exclusively on 2 points: the seriousness of the offense and the speculative concern that Mr. Somerville might stop taking his medication. There was no meaningful discussion of Mr. Somerville's lack of record, his strong family support, that he has stabilized on medication and his treatment plan in place.
Was there a hearing?
There were 3 days of proceedings, Your Honor. It's challenging to call them a hearing, quite frankly, because of the lack of formal procedure, but
So if there was not a hearing, what are we reviewing?
I believe Your Honor's reviewing the denial of judicial diversion, because even if there wasn't a hearing in the most formal sense, I mean, there are transcripts. Mr. Somerville was incarcerated. He's on his appellate bond right now. But Your Honors are reviewing the decision of the court to deny judicial diversion. I'm sorry, maybe I don't understand Your Honor's question.
You're answering my question. I guess the record here is just, it's difficult to, my limited review of the record, it's difficult to discern what actually happened here. And I'm trying to determine what we're reviewing, and your argument about there not being entry of a guilty plea. So that is the primary issue for review.
I would say so, Your Honors. I think that probably is the primary issue for review here. However, I do think that they're not.
So what's the remedy that you're seeking?
The remedy that I'm seeking is remand. It's de novo review and remand to the trial court to properly comport with the requirements of basic due process and a plea.
For entry of a guilty plea?
For entry of a guilty plea, with the hopes and a petition for judicial diversion, Your Honor. And so that might be one of the reasons in the brief that I focus so heavily on the question of diversion, because if this court was to conduct de novo review, we sort of cut out that first issue where we have to remand back.
Well, of course, Mr. Somerville could have a jury trial.
Mr. Somerville could have a jury trial.
Is there any indication in the record? I mean, waiver of a jury trial, that's one of those big ones before we can send someone to prison on a plea. Is there any indication in the record that Mr. Somerville waived his right to a jury trial?
We know, so there's the recording that plays, and that discusses the right to a jury trial. The recording that happens at the start of the hearing, that discusses the right to a jury trial. But individualized plea colloquy, do you understand that you have a right to a jury trial? No, Your Honor, that is not in the record anywhere.
And might it be helpful at this point, Ms. Holland, if we point out for those watching that you it's my understanding, were not the attorney who represented Mr. Somerville in the trial court? Is
I
that
was not,
correct?
Your Honor.
Okay, I just wanted to clarify that for everyone so it doesn't appear that we're asking you questions that you would obviously have known the answer to were you there. You're operating off the record.
I'm operating off of
the same as we
record.
are. Thank you, ma'am.
Yes, Your Honor. But all of those things that I listed, those are all required considerations of Parker and electroplating. Oh, let me go back to my other point. The reason that we would ask Your Honors to conduct de novo review and place this man on judicial diversion is because that was the ultimate outcome that we sought to, that trial counsel sought to have occur in the trial court. And so.
So you're not seeking a remand?
Sorry?
So you're not seeking a remand? You're seeking for this court to place him on judicial diversion? Based on a record that is there where there was no hearing?
I think, Your Honor, I believe procedurally, Your Honors have to remand because of the procedural infirmities within the plea colloquy and the clarity of the record. I think Your Honors do have to remand. But Mr. Somerville is an excellent candidate for probation, for diversion. And perhaps that is my greater point.
He was placed on appellate bond by the trial court.
Sorry, Your Honor?
He was placed, I'm sorry, I'm speaking in East Tennessee vernacular. He was placed on an appellate bond by the trial court, correct?
He was, Your Honors. We had to fight for that, but yes, he was placed on an appellate bond.
Just out of curiosity, and given the circumstances of this alleged offense, was there any supervision that was ordered as a part of the appellate bond? Was he having to report to anyone at this point?
No, Your Honor. He just has a bondsman and typical bond requirements.
Okay.
No specialized kind of probation requirements like we might see, or bond requirements, excuse me.
Sure.
The Tennessee General Assembly has made clear that judicial diversion is not a rare or extraordinary remedy, but a deliberate legislative tool designed to promote rehabilitation, reduce recidivism, and conserve judicial resources. Aggravated assault, while serious, is a diversion-eligible offense under Tennessee law. This legislature could have excluded it, but chose not to. This reflects a conscious decision that even serious offenses, when committed by individuals with no prior record and significant mitigating circumstances, as here, should be qualified for judicial diversion and should be considered for judicial diversion on their individual merits. Appellant is precisely the type of individual for whom diversion was designed. His conduct was the direct result of a documented health episode, not a sustained intent to violate the law. And since the event, he is stabilized on appropriate medication and has a treatment plan in place and is supported by a committed family network. The public policy rationale is clear. Diversion allows defendants to avoid the lifelong stigma and collateral consequences that come with a felony conviction, provided, of course, that they demonstrate amenability to correction. And this approach is not only humane, but practical. It relieves the burden on the criminal justice system of conducting numerous trials. It promotes public safety by addressing the root causes of criminal behavior, like, as in this case, untreated mental illness. The trial court's failure to consider the Parker and electroplating factors was not merely inartful, it was substantive error. The failure to conduct the individualized assessment as required by Parker and electroplating means that his decision should not be afforded a presumption of reasonableness. But perhaps what we can take from this is that when a court fails to ensure a clear, individualized plea and then compounds that error by denying diversion based on categorical reasoning, the reliability of the fairness of the entire proceeding is irreparably compromised. For that reasons, Your Honor, we ask that you remand. Thank you.
Thank you, Ms. Holland. General Levon.
Good morning, Your Honor.
Good morning.
May it please the court, I'm obviously not Miss Katie Neff. I'm Ray Lapone here on behalf of the state.
We were confused. No.
Yes. Well, obviously the state's position is that this court should affirm the trial court's denial of diversion.
Did it deny diversion?
It is our position that the trial court did deny diversion, but to Judge Hickson's question, as it relates to whether or not there was actually a guilty plea in this case, I believe the record will show there is a judgment sheet. There's a judgment sheet that was entered. As far as the state's review of the record, and Your Honors have the record, a hearing was started, and the trial court.
Whoa.
Yes, it was a guilty plea hearing. Yes.
So the judgment sheet said there was a guilty plea?
Yes, on August 8th.
Okay, because I noticed in the state's initial brief, which as you've stated is not yours, when the state stated that Mr. Somerville had pled guilty, that was the citation to the record, the judgment sheet.
Yes, Your Honor.
So is that the only indication in the record that Mr. Somerville actually waived his rights and pled guilty in this case, that little form box was checked on the uniform judgment documents? Is that it?
Well, Your Honor, I guess in taking all these hearings together, obviously, is what we did when we looked at this case.
Well, answer, I want you to answer, because I want to hear the answer as well. Go ahead.
Yes, so looking at this first hearing, which is labeled in Your Honor's volumes as the guilty plea hearing, right? So that's, I think, volume 2.
Ooh.
And that's where the judge starts to go over this defendant's rights. I think the appellant's counsel referred to it. He was doing a plea of several defendants. And so it was announced that there would be a guilty plea as it related to this defendant. And so the judge goes over the rights and then stops it and starts to have conversations with the state, has conversations with defense counsel about whether or not he's wanting to enter a blind plea to 2 counts of aggravated assault seeking diversion. And yes, the trial court at that point starts to inquire whether the lawyers have actually talked about this, and I believe the record will bear this out, Your Honor. That at that point the trial court said, well, you know how I sentence on these kind of cases. Do you want some time to talk about this? And so the lawyers took it. The state took that opportunity, and I believe so did the defense. So they reset the case for that. So at that point, he had gone over all the rights. And I think it's worth...
Are you saying that was sufficient?
Yeah. Does the state think that's sufficient?
Yes. Are you saying that that was sufficient proof of entry of the guilty plea?
Not at that point.
Okay.
So where in the record does it indicate, for instance, that Mr. Somerville said, I understand that I have a right to a trial by jury, and I hereby waive that?
See, my understanding is it's in that first transcript, but if the record, obviously I'll rely on the record.
The one that you just...
Yes, the first volume where he's asking, making sure the defendants understand their rights, but it was stopped at that point. So when the case got reset, they came back. It was announced to the trial court, I believe the record will bear that out, that they haven't reached an agreement. And one thing that is replete throughout this entire record is that the defendant wanted to plead guilty. In fact, defense counsel made that clear to the trial judge. He does not want a trial, Your Honor. He wants to plead guilty. The judge kept inquiring, are you sure you want to earn a guilty plea before this sentencing hearing because you're asking for diversion? And so he made it clear the whole way through up until they had what was the actual final hearing, which is in volume 3, where there's testimony, the defendant testifies, they put on some victim impact, and they start to go into this hearing essentially deciding on the alternative sentencing. So the defendant engages in the hearing, certainly as if he's pled guilty, because he's in the hearing. There was never any mention by defense counsel that, well, wait a minute, we're not entering a guilty plea, Your Honor. And then I believe Your Honor asked some questions as well.
Is that a valid, if a judge is about to send someone to prison, and is that really how this operates? I mean, shouldn't it be reflected on the record that there was, well, let's talk about a written waiver of rights.
Well, there is one. It's signed by the judge. It's just not signed by the defendant.
It's not signed by
Or
the
its
defendant.
attorney.
Right.
So, what are
Yes,
we
to
doing
answer
here?
your question,
I mean, I know
yes,
they
Your Honor.
talked about pleading guilty for like 2 months, but where did it happen?
Right. No,
Did it happen? Are we missing like the hidden transcript that?
I don't believe we're missing anything, Your Honor, and I think that in what the state's trying to respond to is, I mean, obviously there was no motion to set aside whatever happened there. I mean, obviously you could argue, well, how's he supposed to set aside a motion to withdraw a guilty plea if he didn't enter one? But
That would have been my question.
But the decision though for appellate review is, you know, the arguments being made to Your Honors that the trial court did not appropriately go over the electroplating factors, and then even if it did under de novo review, the defendant's entitled to diversion. So that's what the state's responding to.
Well, no, I get that, and, you know, maybe those issues were in the correct order, maybe they weren't, but they did argue, the appellant argued that there was a procedural due process issue here and that he never pled guilty.
Right.
That was part of their second issue. So where does that leave us? I know the state had argued in its brief that you could have a proceeding of this fashion where you made a judicial diversion determination prior to the entry of a plea or the finding of guilt. Does the state stand behind that statement here today?
Yes, right. And well, the argument the state was making, and to Your Honor's point, wasn't that he didn't plead guilty and not that you can actually make a judicial diversion determination without a guilty plea. Our argument was about, could they happen? Does one have to happen before the other? But the state will state on the record they both have to happen. So there does have to be a guilty plea at some point.
So was there
and
a
a
guilty?
hearing.
That gets us back to, was there a guilty plea in this
The
case?
state is submitting that there was, based on the judgment sheets and the fact that they had a sentencing hearing. The defendant never raised that issue anywhere in the transcripts. In other words, there was no point in time where the counsel for the defendant said, wait a minute, my client hasn't pled guilty yet, Your Honor. We can't get into your decision on what's going to happen. And so when this case got brought up on appeal, that issue was certainly raised on appeal, but there's no issue raised there.
Are you saying it's waived?
Well,
I mean, we can talk about plain error if you want to. Do you think it's plain error to send someone to prison without them having pled guilty or being found guilty beyond a reasonable doubt?
well, yes, Your Honor, that would be plain error.
I mean, I just don't
Yes.
understand how the state is standing here and saying, and I understand you didn't brief this and you're in somewhat of an awkward position here.
But it's important, Your Honor. No,
Oh, yeah,
and the state
absolutely.
wants the
I know-
questions.
I know-
We do want the questions, Your
Yes,
Honor, and we understand the
absolutely.
court's concern. Absolutely. And this record is what this record is. You know, and certainly no matter what I argue on behalf of the state, it's not going to change the record that's in front of Your Honors. And, you know, without getting too much into what the trial court did here, obviously there are a lot of concerns that anybody looking at this would have. And so when we responded respectfully, Your Honor, it was really looking at the judicial diversion aspect of this and taking it from an idea that, you know, the guilty plea part of this is that the defendant made it clear and counsel made it clear that he wanted to enter a guilty plea. At every turn in the record, if you look at, and I believe there are three, certainly when the court kept resetting it, that his desire to want to waive a right to a jury trial and enter a guilty plea so he could get to sentencing is clear from that record. But the state is not saying that satisfies your Honor's concerns or questions as to whether or not that actually happened. And to Judge McMullen's question, I mean, the state's back in a position now, well, what is our remedy here? Because in reality, you know, we're trying to just argue that this defendant wanted to plead guilty. He did. Somehow, he got that guilty plea entered. We have the judgment sheets. But what we're arguing is that the judge inappropriately denied diversion. And so that's what we were kind of prepared to argue is, you know, and now we get into the probably not a more comfortable territory as it relates to the judge's development of the record, as it relates to the balancing of the electroplating factors in King. Yes, you've read our brief. I actually made a note here how fast I pivoted to de novo review. But in fairness, like to your Honor's earlier question, it wasn't in this case, but all trial judges don't put those things on the record. Yes, it would make everyone's life easier if they did, but sometimes a judge just starts talking about the case that's before us. Respectfully, I would just quickly submit that this trial court certainly didn't hide what it was thinking when this case got before it. The facts were never in dispute here. The fact that the defendant took a loaded firearm on a public street and with a loaded round in the chamber and pointed it at a mother and daughter who were driving by. And so the court knew those facts, knew that those facts weren't being disputed. And so at that point, the conversation started about, and the judge made it clear on the front end that it was very unlikely that judge would grant diversion based on the circumstances of that offense. And so I know what the state can take the position if you start to pull things out from the record. He did talk about, the mental health of the defendant. He acknowledged the lack of criminal history. I believe there's arguments we make in our brief, and I'll touch on that real quickly, that he looked at the amenability to correction as it related to what mental health treatment plan was in place. That's another reason it got reset too. I believe if your honors look at the record, you will see in the record, it was like, well, bring me some kind of plan. Because I've got an individual that's on the street pointing a loaded gun at two people, and you're telling me he has mental health issues. Well, what's the plan here? And the only plan they came up with was a one-page letter from Pathways essentially saying that, hey, if he makes these appointments. And the judge also had a history, right? And I'm kind of switching a little bit to de novo review for your honors. The defendant testified. He said he didn't even know where he got the weapon. And then he said he had no recollection of pointing the gun. He also admitted that he had a history of mental health illness. That's why his employment history was so sparse. And so the judge has all these facts. So I have an individual with a loaded firearm pointing it at people, and they want me to let them back out in the street with no plan in place. And so, obviously when we pivoted to de novo review, assuming there was a guilty plea, the state's position is that the judge has every right in a case like this, when you're looking at diversion, probation, or even confinement, right? Looking at these circumstances of the offense. I mean, it's easy because, right, aggravated assault under certain circumstances is divertible. And was he eligible? Yes, but that does not entitle him to diversion because, as your honors know, our law is clear. It's not a right. It just means you're eligible. And what takes this out of your normal aggravated assault? Well, the aggravated assault that is actually eligible for diversion in this case has the elements of an offense where it doesn't have to be this egregious, where you can display a weapon, or you can be in possession of an article that's fashioned or looks like a deadly weapon. And in this case, though, he had a deadly weapon. It was loaded. There was a round in the chamber, right? We could stop there. Maybe this doesn't rise or get egregious enough to fall out of a diversion-eligible case based on the circumstance of the events. He pointed it, loaded, at a mother and her teenage daughter, and this judge was confronted with those facts. Now, if the circumstances of the offense weren't enough for the court at that point, well, let's take a look at what plan was going to be in place before this defendant got released on diversion, which is what they were asking for. And he wasn't amenable to correction. I mean, the state submits that. How do you get on the witness stand and you remember everything that happened in your life up until that moment in hearing and you're under oath, and now you remember everything after, but you don't remember pointing the gun out at two innocent people. Oh, you also don't remember where you got it. So now the judge has got somebody in front of him who won't even tell the court how he got this weapon, but the right thing to do as we balance against public interest and what's best for public interest and the accused who has mental health problems, I'll tell you what we do. The trial judge should just put them on diversion and let them out that day. So our position, if you get to the de novo review, is that this is not a case factually where this defendant is appropriate candidate for diversion, just based solely on the circumstances of this particular aggravated assault. I was hoping you had no more questions. If you don't,
I could come up with a few.
I know you could, Judge Hickson. Anyway, if your honors don't have any more questions, the state is asking this court to look at this case and certainly under de novo review, deny diversion.
Thank you.
Thank you, your honors.
Thank you, General.
All right, Ms. Holland? So your remedy again, are you sure you want this to just go back for entry of a guilty plea and a new hearing? Is that what you want?
We want your honors to place him on diversion, but I don't think your honors can because he hasn't affirmatively and clearly pled guilty. I wanted to answer some your honors questions about what was contained in that recording, about what rights they went over. They went over the right to a jury trial, the right to assistance of counsel, right to counsel at trial, right to remain silent, right to confront and cross-examine, right to call witnesses, right to appeal, and the finality of the plea. All of that is contained within that first volume's recorded plea colloquy. But here's what's absent. Notably absent from the advisement, as pointed out, were individualized warnings about certain collateral consequences, such as the loss of firearm rights as a convicted felon or the specific range of punishment for the offense. The advisement was delivered to a group, not tailored to Mr. Somerville individually, and the record does not reflect a personal colloquy or inquiry into his understanding that he was entitled to a jury trial. Or that he understood the consequences of his plea at all. And a couple of factual issues that I would like to clear up here in rebuttal. It's not actually proven that there was a bullet in the chamber of the gun when Mr. Somerville, who had a documented mental health history, experienced a mental fugue state, believing that there were malicious individuals listening in on him. He was having paranoid hallucinations. He exited his grandmother's house, where presumably he got the gun from. He waved it in the street. And then the alleged victim didn't actually drive away from him. She tried to drive toward him in the vehicle. So those are also facts that this court has to consider. It's not, the egregiousness of the actual conduct is not so serious as to deny judicial diversion when there are so many other individual equities supporting diversion here. During the June 17th hearing, I want to return back to the question of whether or not there was an actual plea. During the June 17th hearing, the parties agreed that Mr. Somerville had not yet entered a plea, and the record does not clearly reflect that Mr. Somerville affirmatively pleaded guilty prior to the imposition of a sentence. So even the judgment sheets, Your Honor, that would have been filled out after the hearing. So there is no indication that he pleaded guilty prior to the imposition of a sentence. Of course, this raises a serious question as to whether or not the trial court adequately considered the plea and whether Mr. Somerville's rights were properly protected. And then during the August 8th hearing, The prosecutor actually makes mention that Mr. Somerville has not yet pled guilty. So in the final volume of everything that occurs, the state says something to the effect of, well, today he's going to plead guilty and Your Honor is going to sentence him. And that's how we know that there wasn't a guilty plea here and that his due process rights weren't properly protected. Again, we have a situation where the due process rights and their violation are compounded by the fact that there was not a careful plea entered into this matter, not clear from the record whether it was knowing, intelligently, and voluntarily entered under the requirements of Boykin and Mackey, but that is then further compounded by the lack of individualized assessments, relying on the categorical denial of aggravated assaults in that particular judge's jurisdiction. That's abuse of discretion, that's unlawful, and Your Honors should reverse, you must reverse, because there has been no adequate plea entered, and remand for entry of a guilty plea and petition for diversion. Thank you so much for your time.
Thank you very much, both counsel. Excellent argument. We'll take the matter under advisement. Call the next case, please.
State of Tennessee versus William Goldsberry Jr.